A Friday morning in the middle of July, a quiet street on the north side of a mid-sized Florida city, the kind of street where the trees have grown tall enough to close over the road. Brick houses set back on wide lawns. A man pulling into his own driveway, a little after 11 in the morning, still talking on the phone to a friend, still in the middle of a conversation about nothing in particular, and then he stops in the middle of a sentence. According to the account his friend later gave to investigators, the man said there was somebody in his driveway, somebody he did not recognize. Those were the last words his friend ever heard him say. What came after that, the friend described as a sound, then movement, then breathing that did not sound right, and then nothing at all. The line stayed open. Nobody answered it. Across the street, a neighbor heard something loud enough to bring him to his window. He looked out in time to see a small silver car backing out of the driveway and driving away down the street. He waited a minute. Then he walked over. What he found was a car still running, a garage door standing open, and a man in the driver's seat who could not answer him. He went back to his own house and called for help. In the recording of that call, which is part of the public record, you can hear a man who genuinely does not understand what he is looking at. He tells the dispatcher he heard something loud. He tells her a car pulled away from next door. He says the driver's side window is broken and the man inside cannot respond to him. And then he says plainly that he does not know what has happened here. He does not know. An ambulance was already on its way. The man in the car was named Daniel Eric Markel. He was 41 years old. He was a professor of law at Florida State University, and among people who study criminal punishment for a living, he was considered one of the most serious minds of his generation. He would be gone within a day, and the full answer to what happened in that driveway would take more than 11 years to arrive. It would take 5 separate prosecutions. It would take an undercover operation run on a public sidewalk outside a condominium building. It would take a plea deal with a man already sitting in federal prison. And it would take a piece of audio technology that did not yet exist on the day of the crime. That is not a case that went quiet because nobody cared. Thousands of people cared. That is a case that stayed open for more than a decade because of the sheer distance built into it, the layers of people standing between the hands that carried it out, and the minds that decided it should happen at all. This is Cold Case Model, and this is exactly the kind of case this channel exists for. The ones that took years, the ones where the answer was sitting there in plain sight the whole time and nobody could quite reach it. If that is your kind of story, subscribing takes 2 seconds, and it keeps cases like this one in front of the people who actually want them. That is all I will ask for now, because before we get anywhere near what happened, you need to know who this man was. You cannot measure what was taken until you know what was there. Daniel Markel was born in Toronto in the fall of 1972. He was the son of Ruth and Phil Markel, and he grew up alongside his older sister Shelley in a close Jewish family, in a city he would speak about warmly for the rest of his life. People who knew him as a child describe him the same way, almost word for word. Curious, relentlessly curious, the kind of boy who kept asking questions well past the point where the adults in the room had stopped enjoying the conversation. He argued, not to be difficult, but because he seemed to genuinely believe that ideas got better when you pushed on them. By the time he finished high school, that quality had sharpened into something with a direction. It pointed south, toward the United States, and it pointed toward the law. He went to Harvard for his undergraduate degree. Between college and law school, he spent time in Israel on a fellowship, studying at the Hebrew University of Jerusalem. He earned a master's degree in political theory from Cambridge in England. Then he went back to Harvard for law school and graduated with high honors in the spring of 2001. That is a resume that opens every door in American law, and for a while, he walked through the expected ones. He clerked for a judge on the United States Court of Appeals for the Ninth Circuit, which is the kind of position that hundreds of graduates compete for every year. Then he went into private practice in Washington, doing white-collar criminal defense at a firm with a serious reputation and serious compensation. And then he left it. That is the part of his story people tend to skip past, and I think it is the part that tells you the most about him. He was in his early 30s. He was on a track that ends in partnership, a house in Georgetown, and a very comfortable life. He walked away from it to become an academic, which pays a fraction of what he was making and offers roughly none of the prestige that private practice offers in the world he was leaving. He did it because he had a question he wanted to spend his life on. In 2005, at 32 years old, he joined the faculty of Florida State University's College of Law. He would eventually hold a named professorship there. Now, here is what he actually worked on, because almost every telling of this case leaves it out, and it matters. Dan Markel wrote about punishment. Specifically, he wrote about why the state punishes people at all, and whether it can justify itself when it does. That sounds abstract. It is not. Every single day in this country, courts take people's freedom away. We do it constantly, at enormous scale, and most of the time we do not stop to ask what exactly we think we are accomplishing. Markel thought that was a failure of seriousness. He argued for a version of retributive justice, which is the idea that punishment is not primarily about deterring the next person, and not primarily about protecting the public, and not about revenge either. He argued that punishment is a form of communication, that when a person commits a crime, they are making a claim, whether they mean to or not, that the rules do not apply to them the way they apply to everyone else, and that the purpose of a sentence is to answer that claim, to say, on behalf of the whole community, that the claim is false. He was insistent that this had to be done without cruelty. He wrote at length about the limits. He argued that the state loses its own standing the moment punishment tips over into humiliation or vengeance. He believed the entire justification depends on the state behaving better than the person it is punishing. A man who spent his career arguing about how a society should respond to serious wrongdoing would eventually become the subject of one of the longest and most complicated prosecutions his adopted state had ever run. He did not live to see any of it. I am not going to make that into a neat little irony, because it is not neat. It is just heavy, and it sits underneath everything that follows. What I can tell you is that he was not a quiet academic. Colleagues describe him as prolific to the point of being slightly exhausting. He wrote constantly. He co-founded one of the most widely read law professor blogs in the country, a place where legal argument happened in real time instead of 18 months later in a journal, and he ran it the way he ran everything, which is to say, completely. He organized conferences. He read other people's drafts, including from people he barely knew. He sent notes when he thought somebody's work was good. More than one scholar has said publicly that Dan Markel was the first person to respond to anything they ever published, and that at the time they had no idea why a stranger was reading them that closely. That was just what he did. He gathered people. While he was at Florida State, he met a woman named Wendy Adelson through an online dating service aimed at the Jewish community. She was a law student at the time, 7 years younger than he was. She had a master's degree from Cambridge, the same university where he had done his own graduate work. Her family was in South Florida. Her father ran a dental practice in Broward County. Her mother, Donna, worked in the administration of that business. She had 2 brothers. They married in early 2006 at a large ceremony in Boca Raton. The wedding was announced in the New York Times. Wendy moved north to Tallahassee. She joined the law faculty at Florida State as well, focusing her work on human trafficking, and she published a novel drawn from that subject. In 2009, their first son was born. In 2010, their second son arrived. From the outside, this was the life that people spend 2 decades assembling: 2 law professors, 2 small boys, a house on a shaded street. Careers that had gone exactly the way they were supposed to go. From the inside, according to what Wendy Adelson has said publicly since, including under oath, it was not working. She has said she was never happy in Tallahassee. She found it small. She found it far from her family. She missed South Florida, where her parents and her brothers were, and she wanted to go back. Tallahassee is roughly 500 miles from Coral Springs. In a state as long as Florida, that is most of a day in the car. Hold on to that number. It comes back, and when it does, it is going to sound very different than it does right now. In September of 2012, while Dan was traveling for work, Wendy left. She did not leave a note explaining where she had gone. She took the children. She took most of the furniture out of the house. She emptied the contents of the safe deposit box. Dan came home to a house that was largely bare and found divorce papers waiting for him. Friends of his have said he later described that period using the language of a surprise attack, of something that came out of a clear sky. For a stretch of weeks, he did not know with certainty where his sons were sleeping. He eventually learned they were at her parents' home in South Florida. And this is the exact point where this story turns, so stay with me here, because the rest of it does not make sense unless you understand this piece. Wendy wanted to relocate permanently to South Florida with the boys. Dan said no. So it went to court, and here is what that actually means in Florida, because the legal machinery is the whole story. Florida has a specific statute governing what happens when one parent wants to move a child more than 50 miles away from where they currently live. It is called a relocation petition. If both parents agree, it is largely paperwork. If one parent objects, it becomes contested litigation, and the parent who wants to move has to persuade a judge that the move is in the best interest of the child. Judges look at a list of factors. How involved is each parent? What is the child's relationship with each of them? Will a workable schedule survive the distance? Is the move being made in good faith, or is it being made to reduce the other parent's role? What does the child gain? What does the child lose? Dan Markel was, by every account entered into that record, a deeply involved father. He was not a weekend parent. He structured his working week around his custody days. He was there for the school runs and the meals and the bedtimes. The court sided with him on the point that mattered most. The children would stay in Tallahassee. His custodial rights were protected. He was going to remain a daily presence in his sons' lives, and that presence now had the force of a court order behind it, which meant that Wendy could not leave either, not permanently, not if she wanted to be near her children. The divorce was finalized in the summer of 2013. The relocation question kept coming back. The litigation was bitter in the particular way that litigation between two lawyers can be, with filings about parenting decisions, about the boy's religious upbringing, about conduct, about money. And underneath all of it was a stalemate that no amount of paperwork was going to break. One family in South Florida wanted a daughter, and two grandsons living close by. One man in Tallahassee had a court order that said his children stayed where he was. Testimony given years later at trial described the family attempting to solve this financially. The word used in court was that there were discussions about offering Dan money in exchange for stepping back from his rights. He would not take it. I want to stop reporting for a second here and say something plainly, because I have watched a lot of coverage of this case, and none of it quite says it directly enough. There was no fortune at stake. Dan Markel was a law professor, not a wealthy man. There was no long-buried grudge. There was no affair. There was no debt, no threat, no history of violence, nothing that would ever show up on a risk assessment if you handed one to a professional. The thing that stood between one family and what they wanted was a court order about which city two little boys would sleep in. 500 miles. That is the whole motive. That is it. And I want you to sit with how small that is, because the smallness of it is the single most disturbing thing about this entire case. By the middle of 2014, Dan Markel was rebuilding. He was writing again. He was teaching. He had his sons on his custody days, and he built his entire week around them. He had started seeing someone new. A friend later recalled telling him around this time that he had a girlfriend now, that he was having fun in life again, that he was smiling a lot, and that he needed to start celebrating those things and walk away from the negativity of the divorce. By the standard of the 2 years that came before it, he was doing well. Now, here is what was happening at the same moment, 500 miles south of his front door. Wendy's middle brother was a man named Charlie Adelson. He was a periodontist working in the family dental practice. He was close to his mother, Donna, and close to his sister. Beginning around 2013, Charlie Adelson was involved on and off with a woman named Catherine Magbanua. She was around 30 years old. She had 2 children with a man named Sigfredo Garcia, who had connections in South Florida to a street organization with a long history in federal court. Garcia had a close associate named Luis Rivera. Evidence presented across 5 separate proceedings established that beginning at least 9 months before Dan Markel died, Conversations were taking place about removing him from the situation permanently, and money started to move. The way that money moved is one of the more remarkable pieces of this case, because it was not a bag of cash handed over in a parking lot. It was a payroll. Catherine Magbanua began receiving regular checks written from the accounts of the family dental business. Investigators would later subpoena those records. There was no job title on file for her. There was no work schedule. No documentation was ever produced showing what she did in exchange for the money. The payments were not a single transaction. They continued for a long stretch, including well after Dan Markel was already dead. Think about the difference between those two things for a second. A one-time payment is a transaction. A payroll is a relationship. A payroll requires somebody to keep writing checks, month after month, and to keep filing them, and to keep a straight face while doing it. In early June of 2014, Garcia and Rivera drove north. They came in a rented Toyota Prius, picked up from a rental lot in the Miami area. They stayed in motels. They learned the roads between Dan Markel's house and the places he went during a normal week. They watched. And then they drove home without doing anything at all. A witness later told investigators about seeing the two men at a Tallahassee motel that month. 6 weeks later, they came back. On the 16th and 17th of July, 2014, they checked into Tallahassee motels again. The next morning was a Friday. Dan Markel got up. He got both of his sons ready. He drove them to daycare and dropped them off a little before 9 in the morning. Then he went to the gym, the way he did most mornings, to a fitness center on a main road across town. Camera footage from the gym itself, and from cameras mounted along a city bus route, captured a Toyota Prius arriving in the same window that he did. At around 10:38 in the morning, he left the gym and drove toward home. The Prius left too. Multiple street cameras tracked both vehicles moving through the city in the same direction, minutes apart, heading north toward his neighborhood. At around 11 in the morning, Dan Markel turned into his driveway. He was on the phone with a friend. He said somebody was coming in behind him. He was attacked in his own car, in his own driveway, and he was gravely injured. I am not going to describe it beyond that. It does not help you understand anything, and he deserves better than that. The small silver car reversed out of the driveway and was gone before the neighbor across the street reached his window. His sons were still at daycare. They would be there for hours. Nobody at that daycare had any idea that anything had happened. The ordinary machinery of a Friday kept turning while their father was in surgery on the other side of town. He never regained consciousness. He was pronounced dead the following morning, roughly 14 hours after the attack. He was 41 years old. Before we get into how any of this unraveled, I need to give you the detail that ended up defining the entire case. It is the strangest thing in it, and once you know it, you will not be able to hear it any other way. Inside this family, according to recordings played to multiple juries, what happened to Dan Markel had a nickname. They did not call it a problem. They did not call it the situation. They did not use any of the careful euphemisms that people reach for when they are frightened of being overheard. They called it the TV. That phrase had a history, and we know the history because of an interview that took place on the day of the attack. Wendy Adelson was brought in for questioning almost immediately, which is standard. In an interview that is now part of the public record, a detective told her that her former husband had been badly hurt and was not going to survive. Her reaction on that recording is one of shock. The detective asked her directly whether she would ever ask someone to do something like this. She said not in a million years. He asked whether she thought anyone would do something like this for her benefit without asking her first. She said no. And then, unprompted, she brought up her brother Charlie. She described him as someone who made jokes in poor taste. She said he had bought her a television, and she described a running joke he had made, more than once, that he had looked into hiring someone to deal with Dan and had found that it was cheaper to just buy her the TV instead. She told the detective she believed it was a joke, a bad one, that he would never actually do anything like that. Now I want to be extremely careful here, and I am going to say this more than once in this story because the record requires it. Wendy Adelson has never been charged with any offense in connection with Dan Markel's death. Across 11 years and 5 prosecutions, No prosecutor brought a case against her. She testified in these proceedings. She has consistently denied any involvement. I am telling you what exists in the public record, and I am not going anywhere past it. But that word stuck. It became a shorthand inside that family. And 2 years later, when investigators finally had a way to listen, it was still there, still in use, sitting in the middle of recorded conversations like a piece of furniture nobody thought twice about. So let me stop here, because we are at the middle of this story, and I want to ask you something. The thing that gets me about this case is not the planning, it is the refusal at the center of it. Dan Markel could have taken the money. He could have signed the paperwork, let his sons move 500 miles away, taken his visitation weekends and his summers, and gone on with a much easier life. Nobody would have called him a bad father for it. It happens in family courts every single day. He said no. He kept saying no. For nearly 2 years, through filing after filing, his entire position amounted to 3 words: I am staying. I am still here. That is what he was saying. To a court, to a family that wanted him gone, and most of all to 2 little boys, who were too young to know an argument was happening over them. So here is what I would like you to do. If you have ever had to hold your ground for somebody who could not hold it for themselves, or if you just think a father who refused to disappear from his kids' lives deserves to be remembered for that, and not only for how he died, put the words, I'm still here, in the comments. That is it, 3 words. I read them, and on this case in particular, the comment section usually gets closer to the truth than the headlines ever did. Now let me show you why this took 11 years. Tallahassee police had the scene within minutes, and a dedicated tip line within days, and they had almost nothing to work with. Dan Markel had no enemies anyone could name. He was a law professor. His wallet was there. His car was there. Nothing had been taken. There was no forced entry, no burglary, no robbery that went wrong, no interrupted crime of any kind. Every early theory that detectives could reach for fell apart the moment they looked at the scene. What they had was one neighbor who saw a small silver car leave. So they did the only thing available to them. They pulled every camera they could find in that part of the city, and they built the route backward, hour by hour. The car outside the house, the car on the bus route, the car at the gym, and then they found the one detail that did not belong there. The car had a toll transponder mounted on the windshield. In 2014, that particular kind of transponder was standard equipment in South Florida, where the toll roads are constant, and genuinely uncommon in Tallahassee, where they are not. It was a small plastic box that had no business being in that neighborhood. It was a piece of Miami, sitting in a driveway 500 miles north. Investigators worked that single lead for close to 2 years. I want you to really absorb that. 2 years, on a transponder, detectives, working full-time, on a case with national attention, and the strongest thread they had was a toll tag. Eventually, those records led them to a rental company in the Miami area. The rental paperwork led them to 2 names, Sigfredo Garcia and Luis Rivera. Camera footage from a bank machine placed Garcia in the same vehicle, in South Florida, on the day of the June trip north. By the spring of 2016, investigators had the shape of the whole thing. They believed they knew who had been in the car. They believed they knew who had paid for it. The problem was everything in between. And this is worth explaining properly, because it is the reason cases like this one so often end with only the people at the bottom in custody. In a murder-for-hire case, the people who plan it and the people who carry it out are usually strangers to each other. That is the entire design. There is no meeting. There is no phone call between the person who wants it done and the person who does it. There are intermediaries, and each intermediary knows only the person on either side of them, which means when investigators get to the scene, they find physical evidence that connects to the people at the bottom of the chain and to nobody else. Fingerprints, if any, vehicles, phone records placing someone in a city. All of it points at the hands. None of it points at the head. To get up the chain, prosecutors need one of 3 things. They need someone to talk. They need money they can trace. Or they need the people at the top to say something out loud while somebody is listening. Here, The money had been deliberately disguised as employment inside a legitimate business. The people at the top had never been near Tallahassee, and nobody was talking. So investigators tried something unusual. In April of 2016, an undercover FBI agent walked up to Donna Adelson on the sidewalk outside her condominium building in Miami. He told her he was the brother of Luis Rivera. He handed her a piece of paper. It was a printed news article about Dan Markel's death, and written on it by hand was a dollar figure, 5,000, and a phone number. He told her that his relative had helped her family with a problem they had up north. He said the man was going through hard times now, and he said he wanted to be sure that she took care of him the way she was taking care of the others. Donna Adelson told him she did not know what he was talking about. Then she walked away. That technique has a name inside law enforcement. It is sometimes called a bump. The point of it is not to get a confession on the sidewalk. Nobody expects that. The point is to introduce a single new fact into a closed system and then watch what the system does with it. For nearly 2 years, this family had lived without any physical sensation of being investigated. Nothing had touched them. Nobody had knocked. And then a stranger walked up to a grandmother outside her own home and said, in effect, "We know." The first call she made was not to a lawyer. It was to her son. Charlie Adelson then called Catherine Magbanua. Magbanua then began trying to work out who the man outside the condominium had actually been. And then the calls started cycling back through the family, again and again, for hours. That is the entire investigative theory of this case in a single afternoon. Not a confession, a reaction. The following day, Charlie Adelson met Catherine Magbanua at a restaurant in Miami. The FBI recorded the conversation. And then this case went cold again, for a reason so mundane it is almost painful. The recording was nearly useless. The restaurant was loud. The two voices were sitting close together and overlapping. What was said in that conversation could not be reliably separated from the noise around it, and no responsible prosecutor was going to put a jury in front of audio that could be heard 3 different ways depending on who was listening. The technology to clean that recording did not exist yet. It would take 6 years for it to catch up. In the meantime, the arrests began. In May and June of 2016, Sigfredo Garcia and Luis Rivera were taken into custody. Rivera was already in federal prison on an unrelated matter. Within months, Rivera took a deal. He pleaded to second-degree murder and accepted 19 years in exchange for full cooperation and testimony. And he laid out the mechanics of the whole thing. He described the rented car, he described the motels, he described the trip in June that ended with them driving home, he described the trip in July that did not. He described how the payment was structured and where it came from. He said that as far as he understood it from Garcia, the people paying for this wanted the lady to get her kids back. That was the phrase. That was the entire brief, as it filtered down to the bottom of the chain. Somebody wants a woman to have her children back. He also said he had not been told in advance that anybody was going to be killed. Catherine Magbanua was arrested in October of 2016 and charged with first-degree murder. The first trial began in September of 2019, 5 years after the attack. Garcia and Magbanua were tried together. The state put everything in front of that jury: the camera footage tracking the car across the city, the toll records, the rental agreement, the phone records showing the pattern of calls on the day it happened, Rivera on the witness stand, the checks from the dental practice with no job attached to them. Garcia had no account of his movements that morning that survived contact with the evidence. On the 11th of October, 2019, the jury convicted Sigfredo Garcia of first-degree murder and conspiracy. He was sentenced to life in prison without the possibility of parole. Catherine Magbanua's jury could not agree. Reporting at the time indicated the split was 10 in favor of conviction and 2 against. The judge declared a mistrial. She was tried again in May of 2022. By then the state had refined its presentation. Rivera's testimony was fuller, and the financial picture was tighter. That jury convicted her of first-degree murder, conspiracy, and solicitation. She received a life sentence with additional consecutive terms on top of it. And here is the thing that people forget about this timeline. At that point, 8 years after Dan Markel died, Not one member of the family that paid for it had been charged with anything at all. That changed in April of 2022. Charlie Adelson was indicted. He was arrested the following day. His trial began in October of 2023, and by then, the state finally had the thing it had been waiting 6 years for. The restaurant recording had been enhanced. The voices had been separated. The jury could actually hear it. They also heard from Catherine Magbanua herself, now convicted and serving a life sentence, testifying against him. She told that court that whenever Charlie discussed the arrangement with her before the killing, he would step away from her and call his mother. She testified that on the night it happened, when she went to his house to collect the money, he told her his parents had just left, and she said the cash she was handed was damp and smelled of mildew because, according to her testimony, his mother had washed it. Think about that detail for a second, because it tells you something about how these people understood what they were doing. Somebody, at some point, decided that money connected to this needed to be physically cleaned, not laundered in the financial sense, washed in water. And the jury heard Charlie Adelson's own recorded voice from the day after a stranger handed his mother a newspaper clipping on a public sidewalk, saying that if they were going to charge him, then they should charge him, and that the fact his name had not come up made him think that whoever these people were, they only knew part of the story. On the 6th of November, 2023, the jury convicted Charlie Adelson of first-degree murder, conspiracy, and solicitation. He was sentenced to life without the possibility of parole, plus consecutive terms, totaling 60 additional years. Days after that verdict, Donna Adelson was located at Miami International Airport. She was holding a one-way ticket to Vietnam, a country that does not have an extradition treaty with the United States. She was arrested at the gate. Her trial was the last one. The jury heard the recordings from the undercover operation in full. They heard Magbanua describe the washed money and the empty house, and they heard testimony from women who had been incarcerated alongside her, who told the court that she had spoken about her involvement and had offered compensation in exchange for silence. Before she was sentenced, Donna Adelson addressed the court directly. She said that never in a million years would she have wanted Danny to be harmed or killed, and that she could never do anything that would leave 2 small boys to grow up without him. On the 4th of September 2025, 11 years and 47 days after Dan Markel was attacked in his own driveway, the jury convicted her on all counts. In October, she was sentenced to life in prison without the possibility of parole, with an additional consecutive term on top of it. 5 people were convicted in connection with the death of 1 man. The last verdict landed more than a decade after the crime itself. Now let me step out of the reporting for a few minutes, because there are 4 things about this case that the coverage keeps getting slightly wrong, and I think they matter more than any of the procedural detail. The first one is the framing. Almost every headline written about this case described it as a custody dispute that turned deadly. That sentence is technically accurate. It is also completely insufficient. A custody dispute that turns deadly is a phrase for something impulsive, an argument in a parking lot at a handover, a confrontation on a doorstep that escalates faster than anyone can stop it, something that happened quicker than the people involved could think. This was the opposite of that in every measurable way. This was arranged at least 9 months in advance. It required recruitment. It required a financial structure disguised as employment inside a working business. It required a rental car, 2 round trips of 500 miles each way, motel bookings, and surveillance of a man's gym schedule. And it required a decision, made at least twice, to go home and come back another time. That is the part I cannot get past. There was a trip in June where nothing happened. Everybody drove home. Everybody went back to their lives for 6 weeks. And then somebody made a phone call and said, "Let's try that again." There were dozens of moments across that timeline where any single person involved could have simply not made the next call. Not one of them stopped. The second thing is the reason, and I want to be precise about how ugly it is. The stated purpose of all of this, as it filtered down the chain to the men in the rented car, was to allow 2 little boys to be raised closer to their mother's family. Those 2 boys were the reason it happened. and they are the people it damaged most. Their father died because he refused to stop being in their lives. They grew up without him as the direct result of the fact that he fought to stay. There is no version of that sentence that gets easier the more times you read it. The third thing is about Wendy Adelson, and I am going to say this clearly because the internet has spent 11 years not saying it clearly. She has never been charged with any offense in connection with Dan Markel's death. Across more than a decade, 5 prosecutions, and an enormous volume of evidence, no prosecutor ever asked a jury to find her responsible for anything. She testified. She has denied involvement. Her mother was convicted. Her brother was convicted. 3 other people were convicted. That is what the record says, and that is what I am telling you. The presumption of innocence is not a courtesy we hand out selectively based on how a story feels. It is either a rule or it is nothing. This channel is not going to deliver a verdict that no prosecutor in 11 years ever asked for. The fourth thing is the question people always ask about this case, which is why it took so long. 11 years sounds like a failure. It was not. Look at what actually broke this open, in order. A toll transponder that was out of place. A rental agreement with 2 names on it. A man in federal prison who agreed to cooperate. An undercover agent who walked up to a woman on a public sidewalk and handed her a piece of paper. And a piece of audio software that had to be invented before a jury could hear what 2 people said to each other in a busy restaurant. None of those is a breakthrough. Not one. There was no moment where somebody cracked in an interview room. There was no confession, no witness who came forward, no dramatic single discovery. Every piece of this was small, and every piece took years to become useful, and the case was built out of nothing but small pieces, stacked slowly on top of each other. That is what it takes to reach the top of an arrangement like this one, when the people who decided it never touched anyone, never met the men who did, never came anywhere near the city, and paid for the entire thing through a dental office payroll. The distance was the defense. It very nearly worked. Ruth Markel buried her son, and then she went to work. For years after his death, she could not see her own grandchildren. Under Florida law as it stood, a grandparent in her position had almost no standing to ask a court for anything. The children's surviving parent controlled access, and that was effectively the end of the conversation. So she went to the legislature. She testified. She lobbied. She worked alongside advocates and lawmakers, session after session, on a change to Florida family law. It failed, and she came back. It stalled, and she came back. The result is now known as the Markel Act. What it does is give grandparents the ability to petition a court for visitation with their grandchildren in a specific set of circumstances, including where a parent has been found responsible, either criminally or in a civil proceeding, in connection with the death of the other parent. It is a narrow law. It does not solve everything, but it exists because a woman in her 70s decided that the specific hole she had fallen through should not be there for the next family. That is what she did with it. She was handed the worst thing that can happen to a person, and she turned it into statute. A close friend of Dan's founded an organization in his name in the months after his death. It grew far beyond what anyone expected, with support from thousands of people around the world, many of whom had never met him and knew him only through his writing. A decade after he died, that organization launched a scholarship for law students, carrying forward the kind of work he had cared about. The blog he co-founded is still there. Legal scholars still argue about his work on punishment. Some of them disagree with him sharply, which is exactly what he would have wanted, because he thought disagreement was the point. His 2 sons are older now. They are living their lives. Their father does not get to see any of it. Ruth Markel has said, more than once, that the most important thing about Dan was not the degrees. It was not Harvard or Cambridge or the professorship or any of the writing. She said he was a great father. She said he loved those 2 boys. So come back to the driveway with me one last time. A Friday morning in July, trees closing over a quiet street, a man pulling in, still on the phone, still in the middle of a conversation about nothing that mattered. 2 little boys an hour away at daycare, who would spend the rest of that day playing and eating lunch and taking a nap, not knowing that anything in their lives had changed. A neighbor at a window, a small silver car backing out and turning down the street. And 500 miles to the south, in a comfortable house belonging to comfortable people, a family who had a word for it. They called it the TV. It took 11 years and 47 days to make that word mean something in a courtroom. But it did, in the end. All 5 of them are in prison. The people at the top of it, the ones who never came within 500 miles of that driveway, will die there. Dan Markel spent his career arguing that the purpose of punishment is to say something out loud on behalf of everyone. That when someone acts as though the rules do not apply to them, a sentence is the community's answer to that claim. He did not live to see his own case answer it. But it did. If this one stayed with you, the most useful thing you can do is send it to someone. Like it, leave your thought in the comments, and subscribe if you have not yet, because there are cases sitting unfinished right now that look exactly like this one did in 2015, when there was nothing but a car and a toll tag and a detective who would not let it go. They only ever finish because people refuse to let them go quiet. I will see you in the next one.